Good afternoon. The 14B District Court is now back in session. The court will call the case of Westland Car Care Towing versus Heather Schaefer, 24C. Did I do this backwards? Nope, that's right. Heather Schaefer, 24C0221.
Good afternoon, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
Good afternoon, Your Honor. Stuart Collis on a rare appearance on defense side, P49530.
Good afternoon. All right. We're here for a pretrial in this case.
Yes, Your Honor.
Have the parties talked? Do we think there's any potential resolution? Do we need discovery? Where are we with this?
My opinion is I think this matter is going to settle in the very near future on the basis of the amount in controversy and the fact we have two learned attorneys working diligently to get to that resolution. I'm kind of open. Plaintiff doesn't need discovery on the matter, but to the extent 30 days would help facilitate a window to get the matter resolved, maybe that would be appropriate.
Mr. Collins?
And that's fine, Your Honor. I know that I was chatting Mr. Cox in the meeting area with some suggestions as a settlement. I think, as he indicated, there's not a lot here to litigate. So just that 30-day window, if you would, and hopefully we can resolve it in between.
All right. In that case, I'll keep discovery open until, let's just go with June 28th for discovery being open.
Okay.
And I'll give you a pretrial date for July 11th. A final pretrial date. Does that work?
Something just happened on July 11th to me, so let me double check.
All right.
What was it I put on July 11th? I'll make it work one way or the other, Your Honor.
All right. July 11th, 2024. We'll do it at 2 p.m. again, okay?
Thank you, Your Honor.
And Stuart, can you just email me whatever settlement offer your client has and something in writing that I can run to my client?
No problem.
Thank you. Thank you, Judge.
Thank you. Have a good day. There are no other incidences arising out of this transaction that may come up, right?
That's correct.
Yeah.
All right. Or that have been filed in the past. All right. Thank you.
Sure. Thank you, Judge.
Thank you. Forest Health Medical versus Moises Feliciano, case number 21C0386.
Good afternoon, Your Honor. Stuart Collis on the behalf of the plaintiff.
Good afternoon. Please unmute your device.
Yes,
There you go.
I figured out. Yes, good afternoon. Moises Feliciano.
Thank you.
Your
All
Honor,
right. Go ahead, Mr. Collins.
I'm sorry. I didn't mean to cut you off. I'm just get going when I have resolutions,
I appreciate that.
In any event, Your Honor, we have resolved this case, or I think we've resolved this case, because literally my staff about 5 minutes ago placed a conditional dismissal on my desk. And I'm just going to read it into the record, and if Mr. Feliciano agrees, I can sign his name, and we'll go from there. And
I'm okay with that.
you can tell me what the problem is. So paragraph 1 says, parties have reached a means of resolving the settlement above captioned matter, and defendant agrees to pay the plaintiff the sum of $2,742.44 as full settlement of this account. Paragraph 2, defendant will pay this amount of $600 $85.61 on or before July 19, 2024, and $685.61 on the 19th day of every third month until paid in full. Paragraph 3. In consideration of and anticipation of defendant making this payment, this matter shall be conditionally dismissed without prejudice. Paragraph 4. In the event the defendant fails to pay in accordance with this agreement, plaintiff may submit an affidavit of noncompliance and proof of service to the court for an entry of an immediate judgment. Paragraph 5. The court, upon review of the affidavit and proof of service, shall reinstate the case and enter the judgment against the defendant in the amount of $2,507.62 plus interest from the date of plaintiff's complaint was filed, court costs and statutory attorney fees, less any payments that have been made. Defendant shall remit payments made payable to Collis, Griffer, and Hendra PC at 1851 Washtenaw Avenue, Ypsilanti, Michigan 48197, and should refer to this case number. Paragraph 7, should the defendant complete his monthly payment successfully, the dismissal without prejudice will be converted to a dismissal with prejudice. That is my understanding of the agreement my office and Mr. Feliciano have reached in this matter.
Thank you, Mr. Feliciano. Is that a correct statement of the agreement, sir?
That is correct.
All right, thank you. All
May I
right,
sign your name, Mr. Feliciano?
sir, we need you to answer out loud if yes or no.
Yes, I'm sorry. I didn't
Okay,
see the
that's
correct.
okay. Thank you. All right. All right, I will sign that agreement upon its presentation. Thank you for working this matter through, and I think we're all set.
All right, Your Honor. I'll email it to the
Awesome.
court shortly. Thank you.
Thank you. Have a good day.
You too.
Thank you.
Bye-bye.
Bye.
Court will be on a brief recess until the next matter is ready to be called. All right, the 14B District Court is now back in session. The court will call the case of Next Homes Incorporated versus Sampson Group LLC, Miles Sampson and Sarah Sampson, case number 23C3099.
Good afternoon, Your Honor. Richard Mueller, P58626 on behalf of plaintiff.
All right, is Mr. Lisinski here on that matter?
I don't think so.
Good afternoon, Your Honor. No, I'm here on 3792.
Okay, all right. Well, maybe
stand
we still need to wait just a little bit. I thought I had both attorneys, so I'm gonna
Judge.
get more time to see if the other 2:30 attorney, I think there's an attorney on that case, shows up. So we're waiting for Mr. McAvoy, I guess. All right, thank you. We'll wait a little longer. All right, the 14B District Court is back in session. The court will recall the case of Next Homes Incorporated versus Sampson Group LLC, Miles Sampson and Sarah Sampson.
Good afternoon, Your Honor. Richard Mueller, P58626 on behalf of plaintiff.
Good afternoon again.
Chris McAvoy appearing on behalf of defendant Sarah Sampson only.
All right, so you don't represent the Sampson Group or?
Your Honor, I've entered into a settlement agreement with the Sampson Group and is it
Miles
Sampson?
All right.
And this matter's been put off once, given us some time for Miles to pay, and that would resolve the matter. My understanding, I believe Chris's understanding as well, is that he's waiting for the divorce to be finalized and then some kind of payment from the divorce to be able to pay this dollar amount. And so that's why this is moving forward and kind of been put off a little bit. And I'm not sure where the divorce is at. Fair to say?
I remember now, this case was reinstated as to Sarah Sampson only. I wrote my own notes. If I would just read those, it would be much better for everybody. All right, so as a result, what is the request for today? Do you need additional time, Mr. McAvoy? What do you want to do? Discovery, what would you like to do?
Well, I believe my client's not responsible and this matter could probably be resolved by way of dispositive motion. But before we get to that, the easier path would be is if Miles just paid, then this issue would be resolved as to her and we wouldn't have to argue any further. So I'm okay with the court adjourning it for a bit longer to allow him to come up with the money to pay it. And if not, then a dispositive motion date.
So what I'm hearing is that you believe that once Mr. Miles Sampson gets his monies, whatever that is, from wherever that is, he's going to pay off the debt. It will take care of the entirety of the debt. And then therefore, Miss Sarah Sampson's matter should become moot. Is that how you?
That's right.
Okay. And
would enter a dismissal as to Sarah once it's paid.
I see. Okay, so we all agree on that piece of it. What is the status of the divorce, since that may be the trigger for the money, I guess? When do you think that's going to happen?
The divorce is concluded.
Okay.
He was awarded money from his marital share, half of the marital share out of her 401k.
Okay.
Or a portion. He was awarded a portion of her 401k.
Gotcha.
We have entered a quadro, which has been sent to the plan administrator. So the quadro has been entered, plan administrator has it.
Needs to approve it and
move at their own speed.
Gotcha. Okay.
So
do you know when the plan administrator got it?
month, 6 weeks ago.
Okay, so it could be any time now. In other words, gotcha.
Who knows?
Okay.
But allegedly, they're going to process it timely, which their timeliness and ours are two different. And we're, as attorneys and judges, we move at our own speed as well. So I think we can appreciate how others do it to us, and it's
Some level, on some level.
It does happen that way. So they'll get to it when they get to it, and then he'll get his share. And he has made the representation that once he receives that money, he's going to settle some bills, including this one.
Then what I should do is, why don't I adjourn the pretrial one more time? I'm going to adjourn it 60 days and see what happens. If we're not there, then we should probably set it over for dispositive motions at that point and see if that resolves it. If not, we'll know what path we're on. Okay.
Very good.
Thank you.
Thank you, Judge.
Pretrial is adjourned to August 8th, 2024. And that'll be at 2 p.m.
Very good. Thank you.
August 8th, 2 p.m. All right. Well, hopefully we just get you an order dismissing the case and we won't see you again, but you never know.
Thank
I'm
you. And we don't need any discovery or anything in the interim time period, do we?
I don't think there's anything extended or anything necessary right now.
We'll set it for another pretrial.
No, I don't think the facts are that much in dispute. Just the application of a lot of the facts is all we would really need.
All right. Thank you. You're all set. Have a good day.
August 28th, 2 p.m.
August 8th.
August 8th.
I lied. Okay.
You said it.
August 8th, 2 p.m.
So firm suddenly I'm like, did I say that? Like,
No. Can't trust me. Okay, thank you, guys.
We'll see you on August 8th.
Your Honor, may I ask a question, please?
What's the question, sir?
I just wanted to confirm that 23C 3792 is on your docket this afternoon?
For 2:45, I give them 15 minutes.
Oh, okay. I had 2:30. No problem.
Thank you. All right, the 14B District Court is now back in session. The court will call the case of Credit Acceptance Corporation versus Vanessa Mendoza and Kelsey Lenderman, case number 23C 3792.
Good afternoon, Your Honor. Brant Lashinsky, P84238, Pentic, Covert, Kobalak. I'm here on behalf of Ms. Vanessa Mendoza. I'd like to just update the court. She's been recently married. It's Vanessa Pokoy, P-O-K-O-J.
Thank you.
If I may, Your Honor, she did attest to that in the affidavit attached to our motion for summary disposition.
Thank you. Mr. Andrew Cates was just allowed into the courtroom. Mr. Cates, please unmute your device and state your name and your appearance for the record.
Yes, Your Honor. Andrew Cates, P78292, standing in for counsel of record representing Credit Acceptance Corporation.
Thank you. All right, we're here today in this particular matter because the defendant, Ms. Vanessa Mendoza's attorney, filed a motion for summary disposition in this case. It appears to me, Mr. Lazinski, that the attorneys have, in response to your motion, submitted a copy of the actual contract that was involved in this case. Is that correct?
It does appear to be correct, at least allegedly, Your Honor. Yes.
All right. Yes, allegedly, because your client denies ever signing any such documentation. So you may proceed with your argument as to any other requests. I think that the issue for this court is, I think it creates a clear issue of fact regarding whether or not she signed that document or didn't sign that document. She's obviously submitted an affidavit that I've read that says she did not co-sign and she did not sign this document. It is not a co-sign situation. It is, but she's actually the main debtor in the document and not a co-signer to it. As I read the document, am I correct about that?
Yes, I had reviewed that document as well, Your Honor, and to me, and I read it as such, it says buyer name and co-buyer. So I don't think it assigns a priority of signees, so to speak. So I would consider them both, according to this document, co-buyers, such that they both have theoretically the same responsibility.
Gotcha. I agree.
May I speak on our attempt to contact the second possible defendant, Ms. Linderman?
You may.
Well, Your Honor, we've had multiple attempts to serve Ms. Linderman. I believe she has an alias as well. Her first address we had searched for came up as no forwarding address. Resident moved. The second address said no change of address on file, and there was a gentleman at the house who was quite aggressive with the process server. After several attempts, the process server left a card and received an aggressive message telling him not to ever come back. But we did file a motion for a second summons, which was accepted, and the second summons is due for expiration by July 24th, according to my notes. So we have not been able to locate the other defendant. However, part of our argument is in such that plaintiff should be actually, at least in part, seeking this co-signer to the contract if indeed it is legit. As to our motion for summary disposition, as Your Honor stated, it's become somewhat procedurally awkward in that when the complaint was filed, and as I've spoken to in my reply to their response, there was no attached contract attached to the initial complaint. When our offices contacted counsel's office for a copy of that complaint, they refused to give it to us and said that they would not turn it over until discovery was ordered. Okay, so to us at that point, that made sense to file the motion for summary disposition. We had no document or instrument connecting our client at that point to the transaction. In counsel's response to our motion for summary disposition, as Your Honor obviously knows, there all of a sudden is this contract document attached. Further, in their response, they state twice that it was attached to the complaint. We did double check with the court to see if it had been missed or lost somewhere. It was not ever attached to the complaint. So admittedly, assuming, let's say, for argument's sake, that this is a legitimate document, we had no awareness of it, nor did our client, and hence we filed our motion for summary disposition. Our request in that reply, should this case go forward, I'm happy to see counsel showed up respectfully. There's been some frustration since the very beginning getting communication with brother counsel's firm. But we think our position with our reply, Your Honor, is that there's been a lot of cost that has been attributed to Ms. Okoye Mendoza that could have been avoided had counsel sent us over a copy of the instrument from the very beginning, as we politely requested. So the motion, none of these hearings would have necessarily been required of our client had counsel been willing to work with us on the document. That's kind of my closing. That is why we asked for sanctions in our reply. As this case may have to go to trial due to the fact of this instrument providing some type of evidence in question per the motion for summary disposition, I understand that some of this may need to wait.
Thank you. As to the amount of your request for sanctions?
We asked for $2,500 in our reply. Our clients incurred about $3,168 in defending herself in this matter. We have $40 in court costs, and we've asked for sanctions of $2,500. So total would be $5,708.
What is the amount you spent on this motion, Mr. Lisinski?
We'll have to look. I don't have that figure right in front of me, Your Honor, but I probably can see it in just a matter of moments here.
Right, thank you.
Basically, the motion itself, let's see if I can see it. Okay. Moment. Probably, yeah, on just our motion and our reply. Estimating for expedience of the court, Your Honor, 1,500.
All right, thank you. Mr. Cates, what would you like to say in response, sir? I have looked at the complaint myself. I understand you're standby counsel or stand-in counsel, but I've looked at the complaint myself and I don't see where this contract was ever attached.
Your Honor, from the notes I'm reading, the counsel of record has told me that the complaint was attached. If it didn't make it into the court, then I don't know what to say to that. However, the plaintiff's position on this whole thing is that at least at the time, I know this is changing now due to the circumstances of this case. It was plaintiff's position not to provide documents until discovery was ordered, so it could be done in an orderly fashion, and we wouldn't have to produce multiple copies for Anyways, so that being said, I mean, there was no discovery at the time this case was initiated, and it seems to me, with all due respect to brother counsel, that he just pretty much jumped the gun. Instead of asking for some discovery and making a formal request, that he files a motion for summary.
I'd like to respond when you're done, Counselor.
There's no need for a response.
Yes, ma'am.
Anything further, Mr. Gates?
I mean, what bro- for what opposing counsel has said, I mean, you know, you know, we thought that the contract was attached to the complaint.
Well, there's the problem. There is the problem that I have, Mr. Cates, and it's not with you. I understand your stand-in counsel today. The complaint itself, I'm reading, it says right here in the complaint on item number 2, plaintiff's claim is based on a written instrument which is not attached as it is in the possession of the adverse party. So the response that was provided to this court is absolutely incorrect. And it is clearly written in the document that they filed. And not only that, but when counsel requested a copy of the contract so that he could adequately defend his client, I have a letter here where they said they wouldn't give it to him because discovery hadn't been ordered yet. That is not the way these things are supposed to work. There was no common courtesy in that. I don't feel like he jumped the gun. I felt like instead of him waiting to cost his client more monies, if you don't have proof that she was involved in this matter, he filed the appropriate motions. I do think sanctions are appropriate. I've never done it since I've been on the bench, but this is one of the cases in which I do. Now, as to the amount, that's a different question. First of all, the motion for summary disposition is denied for all the reasons I placed on the record before. There clearly is an issue of fact as to whether or not she was a party to this contract or not. I think the parties are going to need to look into, from what I have here, is an electronic signature. I don't know how those come about, how that happens, and she's denying that she ever did it. So that is clearly a question of fact for the trial effect in this particular case. So therefore, the motion for summary disposition is denied. As to the sanctions, I am not happy with the way that this matter was handled by original counsel for the plaintiff in this case, not you, Mr. Cates, but the fact of the matter is when he asked for a copy of the contract, which they clearly had since they produced it as soon as the motion for summary disposition was filed, they could have given him that and we wouldn't be here. So based on that, I am going to give them sanctions in the amount of $1,000. We need a pretrial date.
Unless we can dismiss this today.
No, it's not going to get dismissed.
Okay. Thank you. Of course.
I understand why you want that, but
No objections, Your Honor. Absolutely respect that position.
I can give you a pretrial of you want 30 or 60 days, and since discovery is such a huge issue, looks like we're going to need some in this case, some real discovery. Do you want 60 days or 90 days for discovery? What do we need?
My inclination, Your Honor, would be 60 to 90 days on this particular matter. I'd leave it to the discretion of the court, or maybe opposing counsel has another opinion.
No, I agree. 60 to 90 days, particularly, Your Honor, in terms of the fact that I would hope Brother Counsel and his firm may be able to help us in this, but it would be helpful for all parties if we could get this Ms. Linderman properly served and party to this action. So 60 to 90 days is going to be, so that date's 7/24 for the second summons to expire. Let's see where we're at. That's about 60. Let's go somewhere between 60 and 90 past the end of July, probably.
I'm going to go to August 29th.
Okay.
August 29th. Well, actually, what I'm going to do is go to, I want discovery to end like a week before then.
You want to on a Friday?
Thursday.
One exact week would be 22,
Okay.
August 22nd.
Discovery through August 22nd. 2024. We'll do a pretrial, another pretrial to see if we're ready for actual motions for summary disposition or whether we're going to be going to trial.
Okay.
And that will be on August 29th, 2024. at 2 p.m. Please have council have someone ready to go and here at the actual time that the case is supposed to start. Today, we had to wait 20 minutes for you to show up, Mr. Cates. I don't know if that's because they didn't communicate something to you properly, but
No, that was my fault, Your Honor. I apologize. I was wrapped up taking care of another matter, and I do apologize for that.
okay, thank you. I appreciate it. All right. We're all set for now. I hope that the parties can talk and try to see if we can get to the bottom of what happened in this matter. So, you know, I don't take any position on who's telling the truth or not telling the truth, but I want to get to the truth. Okay, so let's try to make that happen.
Yes, ma'am.
All
We're
right.
happy
Thank you, Your Honor.
to talk about alternatives.
All right, thank you. Bye-bye.
Thank you.